This is HOA catastrophe. The contractor was ready to work, and she was ready to threaten. I will make an example out of you. That was the first thing Brenda Collins said when she saw the contractor standing on my property with a post hole digger and a string line. She was already walking fast across the driveway, her pink blazer catching the humid Ottawa sun, her flashlight swinging in one hand even though it was 2 p.m. The contractor, a quiet guy named Luis who had been digging fence posts for 20 years, froze mid-swing and looked at me like he was waiting for permission to bolt. Brenda stopped 3 feet from him, planted her feet, and jabbed a finger at the hole he had just started. If he stayed, she shouted, she would call law enforcement for trespass. Her voice carried across the entire cul-de-sac. Luis set the digger down slow, looked at me one more time, and walked back to his truck without a word. I work as a cable installer, which means I deal with easements and property lines almost every day. I know what a setback is. I know what a survey looks like. I know when someone is lying about measurements because they want control. Brenda Collins, pool and amenities chair for the Villas at Lakeview HOA Incorporated, had sent me a fence violation notice 4 days earlier that read like a ransom note. The deadline made no sense. The cited rule did not exist in the covenants. The proposed fine was $200 per day starting immediately, and the notice said I had 72 hours to remove the fence or face a lien. The fence was not even finished yet. I had 1 post in the ground and a string line marking the rest of the run. The notice claimed my fence violated setback, height, style, and an unspecified easement that Brenda said was documented somewhere, but refused to produce. I pulled my original survey from the title company. The fence line I had marked was 6 inches inside my property boundary. The setback requirement in the covenants was 5 feet from the street and 3 feet from any neighbor line. My fence was 7 feet from the street and 4 feet from the neighbor line. The height limit was 6 feet. My planned fence was 5 feet 8 inches. I measured twice. I had Luis measure. We both came up with the same number. When I emailed Brenda a copy of the survey and my measurements, she replied in all caps except, "I am not going to write it that way." She said surveys expire. Mine was invalid, and I needed to hire a new surveyor at my own expense or accept the violation. The stakes were higher than Brenda knew. I was in a custody and visitation routine with my daughter, and my ex had been looking for any excuse to argue that my living situation was unstable. An HOA lien on my property would have given her ammunition. My escrow closing date was also less than 2 weeks away. The buyer's lender had already ordered the title check. Any new lien or legal cloud would have killed the sale and left me holding 2 mortgages. Brenda did not care about any of that. She cared about control. She had spent 3 years as pool and amenities chair turning the community pool into her personal kingdom, handing out guest passes like favors and revoking them like punishments. The same day Luis left, I got a second email. Brenda said I had submitted a records request for the easement documents, and the HOA would provide them after I paid $120 in copy fees and waited 30 business days. I had not submitted a records request. I had asked for a single document she claimed existed. Ontario law says HOA records requests must be fulfilled in a reasonable time, and copy fees have to be actual cost, not punitive. I forwarded her email to my friend Jared, a property manager in Nepean who had dealt with HOA procedure battles for a decade. He read it and called me 10 minutes later. He said the email was a smoking gun. It proved she was stalling and using fake fees as retaliation. He told me to document everything, record every interaction if Ontario is one-party consent, which it is, and get ready for her to escalate. Jared was right. 2 days later, Brenda showed up at my house unannounced at 7 a.m. with a clipboard, a tape measure, and a portable folding sign stand that had a laminated notice clipped to it. The notice had big bold letters, no all caps, saying violation in progress and unauthorized construction. She planted the stand at the edge of my driveway, right where anyone driving by could see it. Then she walked along my property line with her flashlight, shining it along the string line and the single post like she was inspecting a crime scene. I opened the front door and asked what she was doing. She said she was conducting a compliance inspection, which was her right as an HOA officer. I said she was on my property without permission. She said the covenants gave her access for enforcement purposes. I asked her to show me that section. She ignored me and kept measuring. I pulled out my phone and started recording. Brenda saw the phone and her whole face changed. She stopped mid-step, turned toward me, and said if I posted anything about her online, I would be sued for defamation. I told her I was recording for my own records, which was legal. She said it was harassment and intimidation. I said she was the one who showed up uninvited with a sign. She picked up the folding stand, walked back to her car, and shouted over her shoulder that I had 48 hours before the fine started. Then, she got in her sedan and sat there for 5 minutes, with the engine running, just staring at my house. The landscaping contractor working 2 doors down, a guy named Miguel, who I had seen around the neighborhood, was trimming hedges and pretending not to listen, but I saw him glance over twice. That was when I knew Brenda was running a pattern. She was using enforcement as a weapon. The fence was legal, but she did not care. She wanted me to fold, pay the fine, tear down the post, and accept her authority. The problem was I had already spent $1,000 on materials and another $500 on Luis. I had a daughter coming for the weekend and I needed the yard secure because the back gate latch had started squeaking, and Brenda had already sent an email calling the squeak a nuisance and threatening fees for that too. I was not going to let her turn my property into her personal enforcement showcase. I called Jared and told him what happened. He said I needed to get ahead of this. He said Brenda was setting up a paper trail that would make me look non-compliant even if I was right. He told me to file a formal complaint with the HOA management company, request a hearing, and bring every piece of evidence I had. I filed the complaint that afternoon. The management company, a firm called Northview Property Services, acknowledged receipt and scheduled a hearing for the following Thursday. That gave me 6 days. In those 6 days, Brenda escalated 3 more times. First, she sent a certified letter saying my fence post was an attractive nuisance and a liability risk. The letter said if anyone was injured, the HOA would hold me personally responsible, and my insurance would not cover it because the structure was unpermitted. I called my insurance agent. He laughed and said a single fence post was not an attractive nuisance, and Brenda was making things up. Second, she sent an email to the neighborhood group chat, which I was not part of, but a neighbor forwarded to me, saying there was an illegal construction project in progress, and residents should report any further activity to her directly. Third, she started driving by my house twice a day, once in the morning and once at night, slowing down in front of my driveway and taking photos with her phone. The night drives were what pushed me over the edge. I installed a doorbell camera the day after the second night drive. The camera caught her on the third night, parked across the street with her interior light on, holding up her phone and zooming in on my yard. The timestamp was 10:40 at night. I saved the video. The next morning, I got an email from a neighbor I thought was neutral, a guy named Ron who lived 3 houses down. Ron said he had seen my fence post, and he agreed with Brenda that it looked like it might be over the property line. He said he did not want drama, but he thought I should consider moving it just to keep the peace. I asked Ron if Brenda had talked to him. He said no. 2 hours later, I saw Ron and Brenda standing in her driveway having a long conversation. Ron was nodding a lot. I realized Brenda had recruited him. She was building a coalition of neighbors who would back her version at the hearing. I needed my own evidence, and I needed it to be undeniable. I called a licensed surveyor, paid $300 for a rush job, and had him come out the next day. The surveyor, an older guy named Tom with 40 years of experience, spent 2 hours measuring, checking the original survey, and double-checking his math. When he was done, he handed me a signed letter on his company letterhead. The letter said my fence line was 4 feet 3 inches from the neighbor boundary and 7 feet 2 inches from the street. Both measurements were well within covenant limits. The letter also said there was no recorded easement on my property that would affect the fence placement. Tom told me he had done work for the villas before, and he knew Brenda. He said she had a habit of inventing violations and hoping people would not fight back. I had the letter. I had the doorbell video. I had Brenda's emails. I had the timeline. I stared at the violation letter one more time and smiled, because it proved exactly what I suspected. The letter referenced a specific covenant section that did not exist. I pulled the full covenant document from the county recorder's office and searched the text. The section Brenda cited was about tree removal, not fences. She had either made a mistake or she was counting on me not checking. Either way, it was leverage. I called Jared and told him I had everything. He said bring copies to the hearing, bring Tom if possible, and be ready for Brenda to bring her own people. He also said I should expect her to try to control the meeting. He told me to stay calm, let her talk first, and then bury her with facts. The hearing was set for 6 p.m. at the Northview Property Services office, a small building on the north side of Ottawa near the Queensway. I arrived 15 minutes early with a folder full of copies. The surveyor letter, the original survey, the doorbell video on a thumb drive, printed emails, and a highlighted copy of the covenants with the fake section marked. Jared met me in the parking lot. He was wearing a suit which surprised me, and he had his own folder. He said he had pulled the HOA's vendor approval records as a favor. He said there was something I needed to see, but he wanted to wait until we were inside. We walked into the meeting room. Brenda was already there with 3 other people, another board member, an older man named Phil who I recognized from community emails, a woman I did not know who turned out to be the HOA secretary, and Ron, my neighbor, who avoided eye contact. Brenda had her folding sign stand leaning against the wall. She had a laptop open on the table in front of her. She looked at me and said we were waiting for the property manager to arrive, and until then, no recording devices were allowed. I asked if that was an official rule. She said it was her rule for this meeting. Jared said the meeting was a formal HOA hearing, and Ontario law allowed recording unless there was a specific covenant restriction. Brenda did not answer. She opened her laptop and started typing. The property manager arrived 5 minutes later. Her name was Claire, and she worked for Northview. She looked tired. She sat down at the head of the table, opened a notepad, and said we were here to discuss a fence violation complaint filed by Mr. Deuter Collins and a counter-complaint filed by me regarding harassment and procedural abuse. Brenda interrupted immediately and said there was no harassment, only enforcement of clearly stated rules. Claire held up a hand and said Brenda would get her turn. She asked me to present my case first. I slid the folder across the table and started with the surveyor letter. I explained that my fence line was fully compliant, that the measurements in Brenda's violation notice were incorrect, and that the covenant section she cited did not apply to fences. Brenda's face went red. Claire picked up the surveyor letter and read it. She looked at Brenda and asked if the HOA had conducted its own survey. Brenda said a survey was not necessary because the violation was obvious. Claire said obvious was not a legal standard. Brenda said she had photographic evidence. She turned her laptop around and showed a photo of my property line with the fence post visible. The photo had a date stamp in the corner. The date was 2 days before I had even installed the post. I pointed at the screen and said the photo was falsified. Brenda said I was lying. I said the post was not installed until the date on my receipt from the lumberyard, and I had the receipt in my folder. I pulled it out and handed it to Claire. The receipt was dated 3 days after Brenda's photo timestamp. If you are enjoying this HOA nightmare, hit the like button and subscribe, because the payoff is going to be incredible. Claire looked at the photo again. She looked at Brenda. She asked where the photo came from. Brenda said a contractor had taken it during a routine inspection. I asked which contractor. Brenda said it was privileged information. Jared leaned forward and said he had the vendor approval records for the HOA. He said there were 3 contractors on the approved list, and one of them, a landscaping company called Green Edge, had been paid $42,000 over the past year for work that was never bid competitively. He said the HOA's own policy required competitive bids for contracts over $10,000. He slid a highlighted printout across the table. Claire picked it up. Her expression changed. She said this was a separate issue, but it was now on the record. Brenda said Jared had no authority to access vendor records. Jared said the records were public under Ontario HOA law. That was when Phil, the older board member, cleared his throat and said he wanted to see the video I had mentioned in my complaint. I pulled out the thumb drive and handed it to Claire. She plugged it into her laptop and played the doorbell video. The timestamp showed 10:40 at night. The video showed Brenda's car parked across the street, her interior light on, and Brenda holding up her phone and zooming in on my yard. The video ran for 4 minutes. Brenda did not move the entire time. When the video ended, Claire asked Brenda if she had been conducting an inspection at 10:40 at night. Brenda said she was documenting an ongoing violation. Claire said the covenant enforcement policy did not authorize nighttime inspections of private property from a public street. Brenda said she was within her rights. Claire said she was going to recommend the board review the enforcement policy. Brenda stood up. She said this was a coordinated attack, that I had brought a hired advocate, which was not allowed, and that the meeting was over. Claire said the meeting was not over, and Jared was allowed as a witness and advisor. Brenda said she was not going to sit here and be accused of misconduct. Claire said no one had accused her of anything yet, but the evidence raised questions. Brenda grabbed her laptop, unplugged it, and walked toward the door. Ron, my neighbor, stood up and followed her. Claire called after Brenda and said if she left, the board would proceed without her input. Brenda stopped at the door, turned around and said, "You signed the covenants. Now you live the covenants." Then she walked out. Ron hesitated, looked back at the table, and then followed her. The room was silent for a moment. Then Phil, the older board member, said he had been on the board for 6 years and he had never seen Brenda act like that. He said he was uncomfortable with the photo timestamp issue and the vendor payments. The secretary, the woman I did not know, said she had raised concerns about Green Edge before, and Brenda had shut her down. Claire made a note and said she was recommending an internal audit of vendor relationships and a formal review of the compliance chair's conduct. She said my fence was compliant based on the surveyor letter, and the violation notice would be withdrawn. She also said she was going to send Brenda a written warning for harassment behavior, specifically the nighttime surveillance and the falsified photo evidence. I asked what would happen to the fine. Claire said there was no fine because the violation was invalid. She said if Brenda tried to pursue it, I should contact her immediately. I left the meeting with Jared. We stood in the parking lot, and he said I needed to finish the fence as fast as possible, document everything, and be ready for Brenda to retaliate in some other way. He said the vendor audit was the key. He said if the HOA found proof that Brenda had been steering contracts to a specific company in exchange for favors or kickbacks, she would be removed from the board and possibly face legal action. I asked how long that would take. He said weeks, maybe months. I said I had my closing in 9 days and I could not afford to wait. He said the violation being withdrawn should be enough to clear the title. I called my real estate attorney that night and forwarded Claire's email. The attorney said the title company would accept it as long as there was no active lien. There was not. I called Luis the next morning and asked if he could come back and finish the job. He said he had heard through the contractor network that Brenda had been blacklisting people who worked for homeowners she was targeting. He said Green Edge, the landscaping company Jared had mentioned, had a reputation for doing the HOA's dirty work. He said the owner, a guy named Scott, would take jobs from the HOA and then refuse to work for homeowners Brenda flagged. Luis said he did not care about Brenda's blacklist. He said he would come back, but he wanted me to know that Scott had called him 2 days after the first confrontation and told him not to work for me. Luis had ignored the call. I told him I would pay him double his normal rate as a thank you. He said that was not necessary, but he would take it. Luis came back the next day with his crew. They worked fast. By the end of the second day, the fence was up. It was 5 feet 8 inches tall, 7 feet from the street, and 4 feet from the neighbor line. I measured it 3 times. Luis measured it twice. We took photos. The fence looked good. It was exactly what I had planned. That evening, Brenda drove by twice. The second time, she slowed down, stopped in the middle of the street, and stared at the fence for a full minute. Then, she drove away. 3 days later, I got a call from Claire at Northview. She said the HOA attorney had reviewed the vendor audit findings and had refused to represent the board in any further action against me. She said the attorney had found evidence that Brenda had instructed Scott, the Green Edge owner, to falsify the photo timestamp by backdating a file. The attorney had told the board that continuing to pursue the violation would expose the HOA to liability for harassment, defamation, and fraud. Claire said the board had voted to freeze all enforcement actions pending a full policy rewrite. She said Brenda had been issued a written warning and was being removed from the compliance chair position. She also said Brenda was prohibited from conducting any further inspections or contacting me directly. If she violated that order, the board would remove her entirely and consider filing a restraining order. I asked Claire what happened to the vendor favoritism issue. She said the board was conducting a budget review and had discovered that Brenda had approved over $70,000 in payments to GreenEdge without competitive bidding. She said the board was considering legal action to recover the excess payments. She said Scott had already been removed from the approved vendor list. I thanked Claire and hung up. I stood in my yard and looked at the fence. It was solid. It was legal. It was mine. The following week, I closed on the house sale. The title was clean. The lien threat never materialized. My daughter came for her weekend visit and played in the yard. The fence gate latch did not squeak anymore because I had replaced it. Brenda drove by once more, 3 days after the closing. She did not slow down. A month later, I got a letter from Northview saying Brenda had resigned from the board entirely. The letter said the HOA had adopted new enforcement procedures, requiring third-party verification for all violation notices and mandatory board approval for fines over $50. The letter also said the vendor approval process had been updated to require competitive bids and board transparency. I kept the letter. Jared called me a week after that and said he had heard through his property management network that Brenda had tried to run for a board position in a different HOA across town and had been rejected after the new board called Northview for a reference. He said Claire had given them the full story. He said Brenda's reputation in the Ottawa HOA world was finished. I asked if that was enough. He said it was more than enough. He said the vendor audit had triggered a broader investigation, and the HOA's insurance company was now reviewing whether Brenda's actions constituted fraud. He said if the insurance company found liability, Brenda could be personally sued by the HOA for the excess vendor payments. I never saw Brenda again after that last drive-by. The villas at Lakeview HOA continued to operate, but under new leadership. The new compliance chair was a retired school principal named Margaret who sent polite emails and followed the actual covenants. The neighborhood settled down. Ron, my neighbor who had backed Brenda, moved out 6 months later. I heard through another neighbor that he had gotten into an argument with the new board over parking and lost. Miguel, the landscaping contractor who had been trimming hedges during the first confrontation, started doing work for several other homeowners in the neighborhood after GreenEdge was blacklisted. He told me he had watched the whole thing unfold and he was glad someone had finally stood up to Brenda. He said she had been running the HOA like a personal fiefdom for years. The fence is still standing. It is held up through 2 winters and 2 summers. The posts are solid. The boards are straight. The gate does not squeak. My daughter still plays in the yard when she visits. The survey map is framed in my office as a reminder that sometimes the rules are on your side, and sometimes the people enforcing the rules are just making things up as they go. Brenda's portable folding sign stand, the one she used to plant in my driveway, disappeared after she resigned. I heard from another board member that it had been thrown away during a storage cleanout. I wish I had kept it. It would have made a good conversation piece. The vendor favoritism audit concluded 8 months after the hearing. The HOA recovered $32,000 from GreenEdge in a settlement. Scott, the owner, agreed to the settlement to avoid a lawsuit. The settlement prohibited him from bidding on HOA contracts anywhere in Ottawa for 5 years. Brenda was named in the settlement as having directed the overbilling, but she was not personally liable because the board decided the cost of suing her outweighed the potential recovery. The board used the recovered funds to repair the community pool and repave the main street. Margaret, the new compliance chair, sent a letter to all homeowners explaining the settlement and apologizing for the previous board's conduct. The letter was professional, clear, and honest. It was the first HOA communication I had ever received that did not feel like a threat. I ran into Claire, the property manager at a local hardware store, about a year after everything ended. She recognized me and came over to say hello. She said Northview had changed its policies after the Brenda incident. She said they now required all compliance chairs to complete a training program on HOA law and enforcement limits. She said the training included case studies, and my situation was one of them. She said it was used as an example of what not to do. I asked if Brenda knew she was a case study. Claire smiled and said she doubted it. She said Brenda had not contacted Northview since her resignation. She said the last she heard, Brenda had moved to a condo building with no HOA. Luis, the contractor, called me about 6 months after the fence was finished and asked if I would be a reference for a new client. The client was another homeowner in a different HOA who was being targeted for a deck violation. Luis said the homeowner's situation sounded familiar. I said I would talk to them. I did. I walked them through the process, get a survey, document everything, request a hearing, and do not back down if the rules are on your side. The homeowner followed the advice. Their case ended the same way mine did. The violation was withdrawn. The compliance officer was removed. The homeowner sent me a thank you card. I kept it on my fridge for a year. The funny thing about the whole situation is that Brenda never actually succeeded in enforcing anything. She issued the violation. She threatened the fine. She falsified the photo. She recruited neighbors. She tried to intimidate the contractor. She used her position to bully and control. And in the end, none of it worked. The fence went up. The title cleared. The sale closed. The HOA froze enforcement and rewrote the rules. Brenda got a written warning, lost her position, resigned from the board, and became a cautionary tale in property management training programs. The vendor she protected lost his contracts and paid back tens of thousands of dollars. The rules I followed were simple. Know your property, know your rights, document everything, and do not assume the person with the clipboard is telling the truth. The villas at Lakeview is quieter now. The new board is functional and fair. The enforcement process is transparent. The vendors are competitive. The neighborhood feels less like a place where you have to watch your back, and more like a place where you can just live. I still get the occasional HOA email, but they are usually about community events or maintenance schedules. No more violation notices. No more deadline threats. No more nighttime surveillance. Brenda's legacy is gone, replaced by a system that actually follows its own rules. And my fence, the one that started it all, is still standing strong, exactly where it was always supposed to be. Thank you for listening.